Welcome to part 2 of the PFML program. As a brief reminder of kind of where we were last week and where we're going to pick up this week. Last week, we generally covered the premium requirements for the program, some of the other details of who is eligible and who is not, what payments are applicable for those premium deductions and what are not. And today we're going to pick up where we left off with a brief recap on private plan substitutions, something that I'm sure many of you are interested in, and then get into a little bit about collective bargaining agreements to the extent that the information is available. Still a lot to be determined over the next year and a half, I suspect. And then get into some of the employer resources that you can use for yourself and your employees to provide a little more guidance on the program, and then get into exactly the kinds of things that you as an employer should be thinking about in advance of next year with respect to other benefits provided to those employees and other issues that may come up with respect to those other benefits or state laws that may interact with this program. So again, welcome. And with that, we'll get started. All right. So getting back to the final rule overview and the additional information that was provided on private plan substitutions, just as a recap again, employers can request to substitute a substantially equivalent fully insured or self-insured plan instead of using the state program. Applications for a private plan can be submitted on or after April 1 of this year, and substitutions must provide for coverage for all employers with that, all employees within that employer's FEIN. There's an application of $250, and there's also another $250 administrative fee if the substitution is approved. Notably, such fees may be increased on or after January 1 of next year. So if you are considering doing a private plan substitution, I would probably consider doing that on the earlier side before any fees may be increased. With respect to how long the private plan substitutions are effective, the substitutions are valid for 3 years. The exemption from the obligation to pay premiums begins on the first day of the quarter in which the substitution is approved, unless the application for substitution is submitted less than 30 days prior to the end of the quarter, in which case the exemption is effective the next quarter. So again, using kind of this startup period as an example, starting on April 1, employers can apply for private plan substitution. They will need to apply within April or May in order for the effective date of the substitution to go back to April 1. But then if they apply in June, the effective will be for the next quarter, quarter 3, and then they'll stop premium withholdings at that point in time. If employee withholdings were made prior to the approval, the employer must refund the withholdings back to the effective date of the exemption within 30 days of the approval of the substitution. So if you apply on April 1, but you continue to withhold premiums until you hear back from the DOL, as soon as you hear back from the DOL, you'll need to reimburse those employee withholdings at that time within 30 days. The employer is responsible for premiums provided under the Act until the effective date of the exemption, and premiums paid prior to the effective date must be paid and are not refundable. I do see that there are some questions starting to come in the chat. In an effort to fully get through the material and try not to kind of go back and forth and make room for any confusion, I'm going to answer the questions at the end, and I certainly encourage everybody to include any questions they want in the Q&A. I do anticipate leaving some room for questions at the end of the program. If a private plan is approved, employers can choose to start the date of the benefit coverage as of May 1 of next year at the latest. That is when the state benefits are set to begin payment, unless there are any other changes. If an employer does not start the benefit by May 1 of next year, it will be responsible for retroactive payments from the start of the exemption to May 1, 2026. So if you apply on April 1 and you are approved, I would make sure that at the very latest, you are starting those benefit payments by May of next year, because you don't want to have to pay retroactive premiums for that entire year plus period of time. For substitutions approved after May 1, the benefit coverage must begin the first of the month following the approval. Employers can request cancellation of substitution by a demonstration of significant direct negative business impact. Here, they're probably most commonly talking about a significant premium increase with the insurer that you're potentially working with. Employers that cancel their substitution cannot reapply for substitution for 3 years. So then you're going to be working with the state program during that time. If an employer with a substitute plan wants to make a material change to the plan, it must notify the DOL and receive written approval to do so. So, for example, I would suspect that a material change can include something like moving the number of weeks of benefit coverage from 12 to 10 weeks, something that's otherwise allowed under the rules. And there you would have to get DOL approval before you make that change. The DOL also anticipates conducting audits or investigating complaints to determine compliance with the program. And if an employer's plan is canceled due to non-payment of premiums, the substitution will be revoked and the employer will be responsible for premiums starting the next quarter. The DOL will notify employers as of the end date of an approved substitution, so presumably 3 years from now, within 60 days of the end date, and employers must submit renewal applications at least 30 days prior to the end date. If an employer fails to renew or the renewal is denied, the employer must remit both the employer and employee contributions to the fund calculated from the prior exemption date. Employers with private substituted plans must still remit data reports by July 31st of every year. Such employers must also submit contribution reports on a quarterly basis. Those contribution reports being the contributions that you're making to the private plan. And such employers must also provide appropriate tax forms to the employee taking leave based on guidance from the IRS and Maine Revenue Service. As noted in last week's program, there is virtually no tax guidance to date. The DOL did go to the IRS last spring for guidance, and the IRS said that the guidance would be available at the end of the summer. That has not happened, but it does give me hope that the guidance is forthcoming. With respect to fully insured private plans, insurers can offer substantially equivalent private plans. Those insurers must seek certification of private plans and must comply with the Maine Insurance Code. Upon application for certification, those insurers must submit the proposed plan documents with an application form and fee to be determined. The Bureau of Insurance of the DOL will review and approve the applications based on a checklist that's jointly developed by both groups. Insurers may cease offering such plans upon notice filed with the Bureau of Insurance at least 3 months prior to the cessation of the program. And then if there are existing contracts in place that are not going to be renewed, the notice must be provided to the policyholder 6 months prior to the non-renewal. Of note, since last week, my understanding is that the Bureau of Insurance had sent out a letter to all insurers saying that those insurers needed to put a hold on providing any quotes to employers while the Bureau of Insurance develops this checklist and kind of puts the process into place. So there is some questions remaining there as to when the insurers will be able to get certified, and then we'll be able to offer those fully vetted quotes to employers. But given that the private plan substitutions can start happening on April 1, I would expect the certification process to be happening as soon as possible. Self-insured private plans, employers that are going the private plan route that don't want to fully insure through an insurance company can also self-insure those plans. They can request certification of a self-insured plan by submitting plan documents to the DOL, similar to how they would with a fully insured plan. The DOL and the Bureau of Insurance will use a jointly developed checklist, presumably the same checklist for the self-insured private plans, and employers must provide a surety bond in the amount required at the time of the application that it's submitted. Right now, we also don't know what the amount of the surety bond is, but presumably that will be included probably on a percentage basis or some other dollar amount in the application itself. Notably, to have a private plan substitution, the plans are required to be substantially equivalent. Equivalent does not mean identical. To be substantially equivalent, a private plan must provide for family and medical leave to be taken for any reason as provided under the program, provide leave to care for a family member as defined under the program, allow for at least 10 weeks of leave per benefit year, I think to better align with the Maine unpaid FMLA law that provides for 10 weeks of leave. Private plans must also allow individuals to take intermittent or reduced leave. They cannot require employees to pay a greater cost than charged under the program. And they must also provide for an internal reconsideration process. Here, the private plans must also provide for an equal or greater monetary benefit to the employees. So as you remember, and again, these slides will be shared following the presentation as well, but the benefit amount is based on a formula, and the benefit amount that you would be paying under the private plan must be at least as good as that provided under the state program. With respect to appeals, of note, I think this is a good opportunity to say that as we get closer to the end of the year, I will be doing another presentation about like the benefit payments and the application process for benefits and a more detailed appeals summary. But for now, just trying to cover the basics before, as they might apply to things that you do in the next year, even before benefits begin being paid next year. So on the appeals end of things, aggrieved employers and employees can appeal a DOL decision within 15 business days of the date the decision is issued, and such period can be extended for good cause. Aggrieved parties, employers and employees alike, can appeal denial of application for benefits, amount of benefits, determinations of undue hardship, fines or penalties imposed, disqualification or revocation, findings of fraud, or denial of waiver overpayments. So a couple of these scenarios apply to the next year as employers might be applying for private plan substitutions or failing to pay. And in those cases, those employers or individuals can appeal to the DOL on whatever issues come up. I think one important thing to note that was included in the final rule is the issue of advisory rulings. So parties can submit requests for advisory rulings in writing to the Department of Labor. The requests must include the contact information for the person making the request, the facts surrounding the issue at play, the statute or rule of which the interpretation is requested, all facts and assumptions relating to the advisory rule, and a statement indicating that the requester's knowledge, that the issue is not the subject of a pending matter. So if you're asking to get an advisory ruling, you aren't simultaneously engaged in some sort of formal suit or formal process with the DOL. The director of the program can request additional information from the requesting party. Issuance of advisory rulings is discretionary and will be done on a case-by-case basis. And the program will issue a written advisory ruling or notice as to why a ruling won't be provided within 60 days. So hopefully the turnaround time will be pretty quick in getting those answers. Notably, advisory rulings will not be binding upon the program, but if they're published and you are relying on them, any penalties that are provided by the DOL may be offset by some rationale that you were trying to comply with what the DOL had said at an earlier time in an advisory ruling. With respect to other resources, as I said, the PFML website is a great place for all information about the program, compliance information, other resource tools, the comments, the text of the rules, the act, all things which are very helpful during this period of time when everybody's trying to get up to speed. The reason I've included this screenshot is that if you have not already done so, there is, right when you go to the PFML website, type in Maine paid family medical leave on Google, and this is what's going to come up first and foremost. There is this box that says get notified. So I would encourage anyone that is an interested party, which is basically everyone at this point, in Maine PFML, to submit your email address for the get notified there. Anytime the DOL provides any updates for resources, anytime they make changes to the FAQs, as they've done a handful of times, you'll get notified to your email so that you can go and look at that and see, what other questions you might have or what answers they've provided. With respect to other resources, as you can see here, if you keep scrolling down on the Paid Family Medical Leave website, there are resources about the law, the rules, press releases, information about the Benefits Authority, the DOL's own overview presentations, shorter presentation, but has a couple good examples on the benefit calculation, the frequently asked questions, something I would encourage you to reference frequently. The other employer resources, educational webinars, a link to the Maine paid leave contribution portal, which is now live and which employers can now register for. And there's also a contact us information that you can reach out to the DOL directly. I'll note here that the portal opened last week. Since that time, as of yesterday, I believe there have been over 8,500 employers that have already registered for the portal. When the portal opened, the paid family medical leave phone line also opened the same day. So the phone line right now, I gather, is answering a lot of general registration questions, but in the future, we'll be answering other questions about the program details as well. In the last program, I noted a little bit about notice to employees and what that has to look like. For the time being, employers should be posting this labor poster available on the PFML website, in its break rooms, conference rooms, wherever your other employment posters are otherwise posted. This provides a general overview of the program, the benefits, eligibility, and the payroll deductions. Importantly, if you are an employer that has 3 or more employees that speak a different language, primary language other than English, at your location, you are required to post this notice in that other language as well. So there are, without counting, I don't know exactly how many other languages have been published already, but there are at least probably half a dozen or a dozen or so other PFML posters that you can include on that cork board as well. One of the things the DOL has frequently referred to is this one pager. So the one pager is a good reference for how to count your employees for purposes of determining your employer or employee premium liability. It also notes that employers should be preparing to withhold contributions. This one pager was published in advance of the first of this year. So employers, if they are having employees pay into the program, again, noting that that is something that the employers may require that the employees do, you should have those premium withholdings starting now in advance of the premium payment requirement at the end of the quarter. Register for the paid leave portal, again, something that thousands of employers have already done, and then stay informed. Click on that get notified, sign up for the email list, as I've discussed as well. Just getting to a few extra details on the frequently asked questions, things that aside from the formal rulemaking process, the comment process that the DOL has posted in an effort to better explain some of the provisions in the rules or the act itself. With respect to taxability, as I've noted, the big picture tax questions have generally not been answered yet because we're waiting on guidance from the IRS and the Maine Revenue Service. But having said that, premiums are calculated on a total subject wages. So using the $100,000 easy example for easy math, if an employee is tasked with paying 0.5% of their wages as premiums into the program of $100,000, it's going to be $500 over the course of the year, divided into how many pay periods they have. Whether the premiums and benefits are taxable is dependent on guidance from the IRS and the Maine Revenue Service. And employee premium contributions should be listed under box 14 of the W-2 with the label ME PFML. With respect to collective bargaining agreements, another hot topic is there are many employees in the state that are subject to a collective bargaining agreement. Public employers, notably public employers and employees that are subject to collective bargaining agreements in effect as of October 25 of last year are not required, emphasis on required, to participate until the CBA expires, but can bargain earlier for the benefits if desired. The program will apply to all public non-bargaining unit employees immediately. So even though you as a town, for example, might have some employees that are subject to a collective bargaining agreement, the other administrative employees in all likelihood that are not subject to a collective bargaining agreement will need to be complying with this program right away. So paying those premiums right away, even though some of the other employees might be exempt. Public employees that are subject to a collective bargaining agreement will not be included in wage reports until the CBA expires. So for purposes of finding your employee headcount, those employees would not be included until that CBA expires. Very notably, the exemption does not apply to private sector CBAs. So even though there is this exception for public sector CBAs that were in effect as of last year, private employer collective bargaining agreements and those private employers must comply with the program immediately. Employers with private plan substitutions can apply for a new private plan substitution with new insurers, whether fully or self-insured, through the ME PFML portal during the period of substitution. So this is simply to say that, if a year in you're getting a quote from a different insurer, for example, or you decide that you want to self-insure these benefits, you can go and apply again for a private plan substitution through the ME PFML portal. When you do that, you'll be required to pay another application fee and another administration fee. But again, note those fees, currently $250 a piece, are subject to go up next year. The 3-year period of substitution will restart based on that new approval date as well. The locality test for wages, again, something that we've touched upon a little bit. There's more information in the FAQs. There's also more information in the one-pager. But generally speaking, excuse me, if an employer is subject to Maine unemployment insurance, it includes an employee on a Maine unemployment insurance report based on the unemployment insurance locality test, that employee is also subject to Maine PFML. If you have any questions, I'm happy to answer those after the program. I know this issue can be a little bit tricky when you're trying to figure out like remote employees versus employees that are permanently here in the state. So just feel free to reach out after the program. With respect to the employer size, again, it's really important to note that employees with any wages earned in Maine must be included, regardless of the amount of wages earned or time worked. There is an eligibility threshold of the 4 times state average weekly wage for purposes of being eligible to collect benefits from the program if you're an employee. But any wages that are paid in the state must be subject to the premiums. And even if an employee only works, a few hours a year, or maybe is a short-time employee during the summer months, for example, that might not otherwise be eligible to collect benefits. His or her wages are subject to those premium withholdings, should you as an employer decide to withhold their 0.5%. Employer policies and considerations. So there will definitely be lots of things in the future that I'm happy to help answer questions on in the future as well. But when you're thinking about your parental leave policies, your general leave policies, your sick, vacation time, PTO, or the state mandated earned paid leave, those are all things that you're going to want to start looking at in advance of program implementation for purposes of considering how much leave you still want to provide. Right now, there may be employers that have no cap on their sick leave or PTO, or there is a cap that is intended to provide, ultimately 12 weeks of sick leave time if it grows to that amount. And here, now that there's this state mandated program in place, or you're subject to a private plan substitution, you might not have the same need for allowing those employees to accrue that much leave. And therefore, you might be changing the accrual rates or the accrual cap amount. Those are definitely things that you'll want to consider now or in the future as benefits begin being paid next year. I will note again, I noted a couple of times in last week's program that these types of leave, first and foremost, like sick, vacation, PTO, are not to be included while somebody or used, mandated to be used while somebody is on paid family medical leave. So the act itself says that employers cannot mandate employees use PTO, for example, while starting to take their paid family medical leave. This is a big difference between unpaid FML at the state and federal level. So is something you'll want to keep in mind, that employees will have this additional leave to use on top of whatever paid family medical leave benefits they also accrue and are able to use. Handbooks is another thing that I think employers will want to start thinking about. I've put together a sample kind of interim employee handbook provision or section that we've provided to some of our clients. So if you're interested in that, please feel free to reach out to me after the program as well. And I can help you with your handbooks on the paid family medical leave front. Over the next few months, as we see what changes to the program are made, potentially in the next legislative session, or as we kind of fully digest what the implications of this rule are, I will be putting together a longer, more thorough paid family medical leave section, similar to whatever federal or state FMLA sections that you may already have. So please, again, feel free to reach out if you're interested in getting a copy of what that section is or looks like as well. The other big thing, obviously, as we've talked about a little bit, is your choice of program. So you have the choice of going with a state program and continuing to use that, and there are many employers that are simply doing that. You also have the choice of going the private plan substitution, whether fully insured or self-insured. There's a little information that's needed with respect to those insurers getting certification of their plans so that they can then market those to employers. But if you're interested in a self-insured plan, I am currently working on putting together some of that language as well for some clients. So I'm happy to do that for you and your business, depending on what you want to provide for substantially equivalent benefits. Again, noting that it doesn't have to be precisely equal to the Maine state program. So there is a little bit of flexibility there if you're interested in doing a self-insured plan as well. Other employer policy and considerations. So this is something I've touched on. This is something that I definitely will encourage you at the time benefits begin being paid out and somebody takes leave to consult with us about. And that's how this program will interact with federal and state FMLA in the unpaid world. Just a couple brief points about the programs and how they interact. State law says that paid family medical leave will run concurrently with federal or FMLA or Maine state FMLA as they otherwise apply. But there are different periods of leave provided. There are also different requirements for what somebody will need to work or how long they need to be employed before leave applies to them in the unpaid versus paid worlds. So just as a very brief overview, in the federal FMLA, unpaid FMLA world, generally, that's a 12-month requirement, 1,250 hours in a 12-month period prior to leave, and the employer has 50 plus employees within a 75-mile radius. Federal unpaid FMLA provide up to 12 weeks of leave in a 1-year period. Moving to the state FMLA, employees are required to work for 12 consecutive months. And those employers must have 15 or more employees for state FMLA to apply. The benefits that are provided in that case are 10 weeks of leave in any 2-year period, different from both federal and state paid FMLA. And then in the state PFMLA world, all employees, regardless of size, are eligible to take leave. And if they have earned 6 times the state average weekly wage in 4 of the last 5 calendar quarters. The DOL has indicated that in the private plan world, an employer can provide 10 weeks of leave instead of 12, but anywhere I think from 10 to 12 weeks of leave will be provided in a 1-year period on a rolling basis. So if you look at this long enough, as I have, there are situations where somebody might be eligible for paid family medical leave, but would not be eligible for federal FMLA, or eligible for paid family medical leave that would not be otherwise eligible for Maine FMLA. And even if you are a smaller employer with more than 15 but fewer than 50 employees in the state, and you've previously had to comply with Maine unpaid FMLA, you've only had to provide 10 weeks of unpaid leave to those employees within a 2-year period, and now you'll have to provide 10 to 12 weeks every single benefit year, which is a big change. So as these issues come up, as you start to experience situations where somebody will need to take FMLA, unpaid versus paid, I definitely would encourage you to reach out to us, because there are a number of ways that somebody could trip up, providing one or the other, or not both, when you need to, when benefits begin being paid next year under this program. So this will be tricky. It's definitely something to keep in mind. I think on the benefit payment side of things, there is a little lead time before benefits begin being paid under the state program in May of next year. So just something to start thinking about. As a brief reminder of what to do now, again, register for the Paid Family Medical Leave Program portal. There are instructions and some sample webinars on the Paid Family Medical Leave website. Provide notice to the employees. That includes the labor poster, and that also includes providing notice to new employees that you may have. Begin withholdings from the employee paychecks. If you are doing so, those withholdings need to have started on January 1. If you have questions about that, I'm happy to answer those as well. You want to consider your private plan substitution options, consider other benefit changes, amounts, accrual rates, that kind of thing, and then get those employee handbooks updated in advance of full program rollout as well. So with that, I do see that we have a bunch of questions in the chat, so I'll start with those, but please continue to include those in the Q&A, and I'll try to get to as many questions as I can in the next 20 minutes or so. So with that, I'll start with question number 1. So the first question is, if someone works 2 jobs, how do they ensure that they don't contribute more than the max contribution for the year? If you're working 2 jobs, can you file 2 separate claims? So good question. If you're working 2 jobs, both employers will be submitting contribution reports to the state DOL. Those contribution reports and premium withholdings will both be taken care of by the employers themselves. However, there are situations, I'm sure, where one employer decides to withhold the employee contribution from the employee, and another employer decides to pay for that employee portion of the contribution as well. So here, in any case, those employees cannot pay more than 0.5% of their wages. So just using employer A and employer B on a kind of 2-week payroll period example, making this very easy for me, kind of thinking of the example on the spot. If you are working for employer A for the first week and then employer B for the second week, and both payroll periods end on the same time, both of those employers, all of things being equal, can withhold 0.5% from your wages for that period. And then when it comes time to get those benefits in a year, the DOL will have all the information for your total wages for the year from all employers that you might work for, and then provide benefits accordingly based on your total wages. And again, another important piece of this is that those employers can handle how long you take when you are out on leave. And by that, I mean intermittent or reduced leave. So whether or not you are allowed to take an hour, for example, as agreed to between the employee and the employer, or whether you take leave in full day increments. Those things, again, will be things that we tackle as we move into next year. And again, I do plan on providing another presentation probably in the October timeframe for all of our clients to kind of work through some of those examples as well. I have some municipal clients. They have been asking if the elected officials and volunteer call firefighters are subject to PFML. Also, good question. So as you'll remember from the first part of the program, volunteers can be exempt from the program, but kind of short answer without getting into the details of precisely what the working requirements look like for those individuals. If you are getting paid wages for any work done, those wages count towards the PFML contributions, and those employees that are receiving wages would be eligible for the program as well. I think one important thing to note on the volunteer side is that those individuals can get a quote unquote nominal fee for their services. For that, I expect that would include reimbursement for travel expenses if you're traveling to a town board meeting that you're volunteering for in a volunteer capacity, or something like a lunch credit or something. But not something significant, not $1,000 or multiple thousands of dollars for those services. Again, if you want to reach out and talk more through any of these questions that I answer, please feel free to do so after the program. Next question, if an employer is paying unemployment taxes to another state, such as Massachusetts, for an employee since the employee resides in another state, is the company exempt from paying premiums for the Maine PFML for that employee? Generally speaking, yes. So if you're paying unemployment insurance premiums for an employee to another state, you would not then need to pay the premiums to the state program, the Maine state program. There is, I'll just note, a tricky issue, which I've yet to get a little more information on. But in the final rule, the last iteration of the rules, the DOL included this provision that if you are providing benefits through a private plan substitution, that all employees within that employer's EIN need to be eligible for the program. Presumably that you could be an employer with a single EIN that has employees out of state, perhaps Massachusetts, which has its own paid family medical leave program. So how that specific provision will play out for those employees and what benefits are provided to those employees that might otherwise have other paid family medical leave benefits themselves to another state program remains to be seen. But again, yes, short answer is that if you are paying unemployment insurance premiums to another state, that employee is not included in your head count, and those wages that are paid through that unemployment insurance program are also not included in your contribution. Next question. Does the private plan take the place of the state plan, or are they just a middleman between an employer and the state? If we use a private plan, are we telling employees to go through the private plan for a paid leave benefit, or are we telling employees to go through the private plan for the state paid leave benefit? So short answer here is that the private plan is a wholly different plan from the state program. The benefits that are provided, the requirements, the payment levels, those will all be similar, depending on what you do or which insurer you might go with. Of course, there might be a cost difference to you as an employer, depending on going with insurer A versus insurer B. But the program itself will be wholly separate. So if you get approved for a private plan and you start those private plan benefits at the same time that the state program starts in May of next year, those employees that go out on leave at that time will apply through the insurer for those benefits and will not otherwise interact with the Department of Labor. Having said that, you as the employer are still required to submit contribution reports to the Department of Labor and other information throughout the year, which simply indicates that you are providing this benefit to those employees and you're otherwise complying with the requirements of the law and the rules, but separate programs. What is the likelihood of approval for self-insured plan for employers who already have leave programs in place, like FMLA, short-term disability, parental leave, etc.? Another good question. So here, the private plans that you put in place have to be substantially equivalent. So an STD policy, for example, short-term disability policy, will not by itself meet the requirements of this program. In order to meet the requirements of the program, you have to provide the substantially equivalent benefits, rights, and protections as provided under the program. So there you'd have to provide leave for a family member's medical condition, or your own personal medical condition, or safe leave, or an exigency, all the reasons that are provided under the Act. So by itself, one of these other programs will not provide the same benefits or the substantially equivalent benefits as needed to comply with the private plan substitution rules. The DOL, BOI have not published the checklist yet. I'm not sure if they are going to do so. But generally speaking, if you are self-insuring or anticipate self-insuring and trying to get approval for one of those plans, the benefits that you're providing need to be as rich, if not more rich, than those provided under the program. The cost has to be at most the same cost to those employees, and then you're looking at a 10 to 12 week period of paid leave as well. If you have additional questions on that one, I know in the self-insured world that's probably the trickiest thing to look at, but I have spoken with a number of employers already that do plan to go the self-insured route, so you would not be alone, and theoretically there might be cost savings to you there as well. If a company has not yet started deductions from employees, are there any penalties for not doing so? I have heard in another presentation that employers can't go back and collect payments for deductions missed. Is that true? Simply put, yes. You can't go back and collect deductions that are already missed. You have to provide notice to those employees at least 7 days in advance of their next paycheck that they're going to have those deductions withheld. And then from that point on, you could continue doing so, but you'll need to provide with, comply with the notice provisions that set out under the rules and the law. Having said that, if you miss the January 1 deadline, that's okay. You're going to be responsible as an employer for paying the full 1% if you're 15 or more employees. But after you give notice to the employees, if you want to start withholding from them, you can do so for the remaining period that you are paying these premiums into the program, at the very least before you apply for a private plan substitution, if you do so in April or later of this year. Next question: if you are a private employer with a CBA, are subject to bargaining the impact of are you subject to bargaining the impact of implementing the members of the CBA paying the 0.5%? Wonderful question. One that we've had a lot of internal discussion here about. This is a question I think is probably best answered offline, but there has not been guidance to date, or at least clear guidance to date, on an employer's responsibilities or requirements during this bargaining process if you plan to have employees pay into the program. So again, if you have additional questions or want to talk through this further, I definitely would encourage you to reach out to us, as this is very much a tricky issue. As we start up this program and start paying premiums into the fund. Next question: we have a lot of remote workforce. We use an HR database that all employees have access to through their phones and computers. We post everything electronically, and at our corporate office, we also have paper posters, quote unquote paper posters. Does this meet the notice requirement? Great question. What I think what I would do in this case is make sure that all of the employees at your business or in your business, whether remote or not, have received the labor poster. That's a good place to start. From then on, you can determine whether or not the wages that those individuals are collecting are subject to the premium requirement, and whether under the employee headcount test, the 15 or more employees in a 20-week period during a calendar year, whether or not those employees then would also be under the program, and what your contributions are. So here, I think for notice purposes, if you have a Maine employee that's collecting wages in Maine, you'll absolutely want to provide notice to them. But if there's some sort of central location, through your internal, intranet or business website that only employees have access to, you can also post this on that with the other resources as well. Next question, if the employer currently offers paid parental leave, are you saying they cannot offset the benefit with Maine paid leave and have them run concurrently? Yes, that is what state law mandates. You cannot reduce, you cannot require employees to use their PTO, vacation, sick time, parental time, any other time that you're providing as a benefit to those employees at the same time that they are using paid family medical leave benefits. However, this is why you will want to be looking at whatever parental leave is offered, or if you are supplementing the paid leave benefit. I know, for example, a lot of employers, most employers maybe, provide short-term disability benefits. The final rule provided that short-term disability benefits will not offset paid family medical leave benefits. But employees can only receive a combination of paid leave and short-term disability benefits up to their typical weekly wage. So if there are other ways that you want to provide parental leave, for example, on top of paid leave benefits, you can definitely do so. But if you have, let's say, a month-long parental leave policy, the first month that individual is out under the paid family medical leave program, they could supplement with the benefits provided under the parental leave policy, but they are not one and the same. So again, if you have questions, happy to answer those, but that's definitely one of those policy considerations that you're going to want to look at between now and when benefits begin being paid next year, with parental leave, vacation, PTO, etc., especially where somebody might be able to recruit hundreds of hours over the course of however many years, and it's intended that they use those benefits in a situation like this before the program is in place. So is PFML 10 or 12 weeks? The program itself provides for 12 weeks of leave. I want to be very clear on that. If you are using the state program, it will be 12 weeks of paid leave. However, if you are choosing to go the private plan route, your private plan only needs to be substantially equivalent, not equal. And the DOL has said that a plan that provides 10 weeks of leave that is otherwise, substantially equivalent to the state program, that will be or constitute an approved plan, or can get approval as a plan, I should say. So it can be 12, but the state plan will provide for 12 weeks of paid leave. Next question, do you have to apply for both when needed? I'm not sure what this question is getting at. If you are referencing applying for the private plan substitution, you do, as an employer right now, need to register for the portal, even if you intend to go the private plan substitution route. And then beginning in April of this year, you can start applying for the private plan substitution when you make other premium and contribution reports for this first quarter. If I'm not answering the question, please feel free to provide a little more detail in the Q&A as well. What is the difference between Maine FMLA and paid family medical leave? So prior to the enactment of this paid family medical leave program, Maine also had its own unpaid family medical leave law, similar but not identical, certainly not identical to federal family medical leave requirements. The eligibility is different. The amount of leave is different. So this program will provide paid benefits while the other law is still on the books. So again, quick reminder, the other law provides that employers have to provide 10 weeks of leave in any 2-year period. An employee has to be employed for 12 consecutive months to be eligible for the program. Here, in some senses, the paid family medical leave law under Maine law will, I want to use this term very loosely, kind of supersede the unpaid program, the unpaid leave FMLA law, in the sense that employees can apply for benefits right away. They might only get protections if they're there for some period of time, but they can provide right away. They need to start paying right away. There are differences, but again, this is where, you know, these different types of leave may or may not overlap when somebody begins taking them, you know, next year when the paid family medical leave program is in place. And that's when I would definitely encourage you, if you're confused as to what applies and what doesn't, or how these might interact, please feel free to reach out to us, and we're happy to go through those things. Last couple questions, try to answer these quickly. I will stay on for just a couple more minutes past 1 to try and get through these questions, understanding that some people will have to jump off at that period of time. Next question, would you require that employees complete the usual FMLA paperwork in addition to submitting PFML paperwork to the state? Generally speaking, yes, especially where there is the overlap. I would have them still fill out the same paperwork. Notably, we do not have any forms of virtually any kind about this program, this paid family medical leave program, from the Department of Labor. I do anticipate that they'll probably publish some, like the application form or, you know, whatever other requirements they might need to provide as part of the application process. There will be an authorization statement that an employee can sign that will allow the Department of Labor to go request information from a medical provider, for example. So there are differences there with how these will be rolled out. But generally speaking, yes, we'll want to use the same or similar paperwork through this process as well. Is there anything you can share about the legislation and the pending lawsuit submitted to challenge the law? Not at this time. I would encourage anybody that's interested to go look at the complaint. The complaint will have all the information about what in fact is being challenged and not the law. I know some of the news networks started picking that up last night, but I'm not in a position to comment on the pending lawsuit. As a Maine employer, is an employee entitled to 10 or 12 weeks of unpaid FML? I was always under the impression that it was 12 weeks every rolling year. So it depends on the size of your business. If you are a business of 50 or more employees within a 75 mile radius, and the employees otherwise meet the length of service and hour requirements, then you would have to provide 12. If you are only subject to Maine unpaid FML, that provides for 10 weeks of leave in a 2-year period, again, with its own eligibility questions. That slide is very important for raising the issue that there are ways that these will interact and in some cases run concurrently, but there are different requirements that will play out differently depending on the circumstances too. So definitely worth encouraging you to reach out to us if you have any questions. So federal and state leave. So I think this question relates back to do you have to apply for both when needed? If you are applying for FMLA generally, you would be using the forms that you already have. If you're applying through the Maine paid leave program, you'll be providing notice to your employer, and then the application itself will go through the Department of Labor, who will then make the determination as to when you can take your leave and what the benefits are and whether the leave is approved. Should SERP payments made to retirees be subject to the tax? So here I'll refer you to the definition of wages under the rule and the law itself. I quite frankly don't want to slip up on this without referencing that, but happy to answer the question after the fact if you want to email me as well. Two questions left. How would you recommend a company with a 6-week paid parental leave coordinate the benefits under the new PFML? Would you reduce the paid parental leave payments by the amounts paid through Maine paid family medical leave? This is definitely getting into the legal advice realm, so something I'm happy to take up after the program as well. But there will be ways that you can communicate to employees reductions or increases in current benefits to better align. If you want to talk briefly about what that will look like, I suspect that would be a relatively short conversation on this specific issue, and I'm happy to answer that offline as well. And then would Pierce Atwood consider putting together a flow chart to help determine which leave, Fed FMLA, Maine FMLA, PFMLA, is available for an employee? Yes, the one of the last slides there was kind of the beginnings of that, just to kind of flag that there are ways that these programs will interact or not interact. But as we get closer to full Maine paid family medical leave implementation, I'm happy to walk through those and kind of expand upon that chart as well, just so we can get a better understanding. Good place to just remind everyone again that we will plan on holding another program, at least one other program in October, talking about the application process and the appeals process and how this will really start up next year. If we receive a lot of questions over the next few months, I'm also happy to just do a simple, Q&A session with no prepared materials, but to just kind of do this back and forth with people answering questions as well. But in the meantime, please feel free to reach out to any of us here in the group, and we'll do the best to answer your questions in the meantime. Having said that, I will skip, I think, to the last slide here, just so that you have my email and phone number. If you do have questions, please, again, feel free to reach out. I'm happy to answer anything that might come up over the next few months as we all prepare for this program. Thank you very, very much for joining us today. We really appreciate being your counsel and are happy to help with whatever comes up in the future. So thank you. The slides will be sent out after the program, and if you have any questions, we're here. Have a great day.